make the best use of the time to elect a chairman first. Ms. Sit Ho and Mr. Albert Ho. Any seconder? If we don't have a seconder, we can't elect a chairman. Ms. Ann Chang, are you seconding or are you interested in becoming chairman? I can nominate you. I mean, chairing the meeting. Okay, fine. Chairman, can I nominate myself? No. Can you nominate yourself, I mean? Yes. You mean you want me to nominate myself and then Ms. Sit Ho can second? Ah, you don't want to second me. Now I know. Well, you can nominate yourself, then I can nominate myself. Okay, fine. All right, I nominate myself and Ms. Sit Ho seconds. Any objection? And any other nomination? I nominate Ann Chang. I do not second, said Ms. Ho. Is it that a seconder can only second one nomination? Can someone second two nominations? But I don't second, Ms. Sit Ho said. Well, now you know, the minority in a meeting cannot become chairman. No, I think Mr. Albert Ho has the professional background, so I support him becoming chairman. But if Mr. Albert Ho is a member, then you can ask many more questions. All right, I can second the nomination of Ms. Ann Chang, and now it's 2-1. So, Ms. Ann Chang, you can now take the chair. You don't need my agreement. Just take the chair. Please do not play games. No, she nominated you. Come back to the members' seats, Mr. Albert Ho. No, she nominated you, but then you nominated yourself, and Ms. Sit Ho seconded you. You can become a chairman. I nominated myself, but I was not seconded. No, I seconded you, said Mr. Albert Ho. Now, do we need a vote? Let us take a vote. Oh, please. Nobody seconded my nomination. No, Mr. Albert Ho not seconded your nomination. All right, we don't need a secret ballot. Those who support Mr. Albert Ho. Those who support Ms. Ann Chang. But I'm the minority. Okay, 2-1. So you take the chair.
但係你係咪好想做啊？投咗票嚟嘅啫。唔係我。我跟議事規則，做議員咧一定要爭取做好啊。咁我哋而家請政府，我哋停一停，跟住啲嘢先啊。好啊，咁啊，多謝啊。
I'd like to thank Mr. Albert Ho for seconding the nomination of me being the chairman of this subcommittee. Now we can invite the administration team to come in. Chairman, at 11 o'clock I will have to leave. Can you please allow me to ask one question? That is the whole purpose of my joining this subcommittee.
12.9 OK 嚇，係唔使噶啦，你可以舉手得噶啦你。
You just have to raise your hand now. Okay. She will be the first in the queue to ask a question.
要走啦，所以我想
I need to leave early. In fact, I'd like to ask the question before the officials brief us on the background. I read the legal brief, and in fact, I don't need you to spend time on briefing us.
我哋不如又咁啦，咁啊。
Let us do this. Since the officials have come in, we can now ask the officials to brief members. Chairman, I was saying that I believe we have all read the papers, and these rules are comparatively simple. Can we now go straight into question and answer? Ms. Ho, I understand, but members of the public are watching the proceedings of the meeting, but they have not read the papers. They need to know what the meeting is about. Okay, Chairman, let us go for efficiency. Quickly, please. Okay, Chairman, I will very quickly run through the paper. We are proposing 6 sets of subsidiary legislation relating to suitors' funds rules. Suitors have to deposit funds in the court for different reasons. We have rules to regulate the management of the funds, for example, how they should be paid out of court and lodged in court, and how interest should be credited to accounts. Now, there are 4 courts that have their own rules, but the CFA and the Lands Tribunal have operated the rules administratively with reference to the practice in other similar courts. Last year, we amended the Administration of Justice Miscellaneous Provisions Ordinance 2014 in order to amend specific rulemaking powers, and that was endorsed by the LegCo. And in July, we also prepare for the full operation of the new competition tribunal and has prepared a new set of suitors' funds rules that was also passed by LegCo. These 6 sets are proposed as another step of the same exercise. We have new rules for the CFA and the Lands Tribunal, and the other 4 sets have been improved upon, and there are 2 ways to improve them. We have changed the interest counting days from the 14th day to the 3rd business day, and also the accounts office hours of payment will now generally tally with the opening hours of the account offices, and I won't go into other detailed miscellaneous amendments. We have already got the agreement of the Bar Association, the Law Society, and the relevant committees of the LegCo. Now we will be happy to take questions. Thank you. Officials, you have very briefly gone through the business for this subcommittee. I understand Ms. Sit Ho is hard-pressed for time. Ms. Ho, now you can ask a question. Thank you, Chairman. My question does not have to do with the accruement of interest. Rather, I'd like to know in what circumstance you would require a suitor to deposit the fund. The Lands Tribunal would require funds to be deposited. We have questioned that. Very often at the Lands Tribunal, there would be disputes about land resumption or clearance. One of the parties might be an owner of a very old flat, and always these small owners lose cases at the Lands Tribunal. It has been very rare when they have been awarded the compensation. And I'd like to ask about a relevant question at the Labor Tribunal. If the labor side appeals, it goes directly to the High Court. So in what circumstance would the judge stipulate that funds should be deposited? If it is a labor dispute, the labor side can only get legal aid from 2 ways. One, by applying for legal aid. Is it that the Labor Tribunal would know that this one is receiving legal aid, so a fund will not have to be deposited? And secondly, the expanded legal aid supplementary scheme. And very often the compensation would be less than $100,000. However, the service can be costly as well, and if they want to appeal, they have to dig into their own pockets. And if that's the case, that would mean that you are closing the door for them to lodge an appeal. So when you ask for funds to be deposited, what is your consideration about labor disputes? Okay, officials, under what circumstances would funds have to be deposited? What if people do not have money? I will kick off and then I'll ask Mr. Chan to supplement. Now, when funds would have to be deposited as suitors' funds, that would be decided by judges, and the judge will look at the circumstances of each case. Mr. Chan will give a general reply, and then I will go to the specifics about the Labor Tribunal. Mr. Chan. Thank you, Chairman. About Ms. Ho's question, as Ms. Zhang was saying, the court has discretion in giving consideration to the overall circumstances of the case in order to decide whether the appellant has to deposit a fund. and this would be for security for costs. In what circumstance would the plaintiff or the appellant have to deposit a fund? In general, there are a few circumstances. Say the plaintiff is a company registered overseas with no assets in Hong Kong. The court will consider this. And if the case is an appeal case, the court will have another consideration, and that is whether the appellant has a locus, or is it just for the sake of delay. If the court thinks the latter is the case, it may ask the appellant to deposit a security for costs. The court has a lot of discretion in requiring the deposit of funds by appellant or plaintiff. The court may not require the deposit of funds in every case, whether it be the plaintiff or the appellant. It really depends on the cases involved. Mr. Chan, can you clarify more? I think Ms. Ho is really asking you whether deposit of funds will be required only of overseas incorporated companies, and also when appeals are lodged for the sake of delay. Let me add, I can give you more examples. In our paper to the legal advisor in para 11, we cited the example of High Court. First of all, it is because if damages are provided to people who are mentally incapacitated, and if it is a civil case, and if it is about sanction payments, and also number 4, you have to pay into the court, and then the funds will be managed by the court. As for the Labor Tribunal, last year when we proposed the miscellaneous amendment bill to members, we particularly mentioned in what circumstance the Labor Tribunal can require the parties to deposit a security for costs. Generally speaking, the court may regard the claimant to be doing this for delay, or may abscond with the funds, or can lodge an unreasonable complaint in order to delay the administration of justice. When the amendments were made, members welcomed the listing of such clear causes, and the principal ordinance has been passed.
Chair, can I interpret it this way? In the event of a labor dispute, the court ruled that a suitors fund would need to be deposited into with the court. Normally, this would be the case when the employer is trying to delay the case, or when the party concerned is a company registered overseas. So I'd like you to give us a paper to tell us whether or not the court has actually made a ruling in respect of a case which was given legal aid, and the person concerned was required to pay a suitors fund. And if that's the case, how would the legal aid department deal with that situation? Let's see whether or not there's any precedent. We want the assurance that if the judge is satisfied that you don't have the means to contest the case. So I think we would like to know whether the judge had actually required such a party to pay a deposit into the suitors fund. Yes, could you give us more details? You were telling us that the employer may have to pay into the suitors fund. Under what circumstances would the employer have to pay into the fund as well? In amending the subsidiary legislation, I think we noted that both employer and employee may be required to pay into the fund. We were certainly willing to go back to see whether or not there have been any such cases initiated by the employer. I think the answer is that the employee side may not be the poorer party. So it would depend on the nature of the case. And also we would look into the circumstances of the person, including his financial background, that depend before we decide whether or not we require him to pay security of costs. We'll certainly be willing to go back to see whether or not there's any record, and then share them with members. Chairman, Madam Chair, I did not take part in the scrutiny of the subsidiary legislation. It's the first time that I am participating in deliberation on this subject. Now, my question is that if the appellant is already given legal aid, and you're already satisfied that he is not someone with substantial means, he would normally be the weaker party of the case. So I would be happy if the government could give us the figures. We will try the best to look up the information that you asked for. Mr. Albert Ho, thank you. I think the amendment is actually a consequential amendment, and it's also very technical in nature. I don't think there's any dispute as far as the policy is concerned. I did not take part in the deliberation on the principal legislation. My question is that after this round of amendment, then the Suitors funds rule will be uniform across the board. Well, we can only say that they are basically the same. The 6 courts, including the Competition Tribunal, altogether 7, they all operate in different ways. For example, the CFA is rather unique as a court. For example, the CFA will not be involved in any enforcement. So anything that involves enforcement will not need to appear as far as the Suitors Fund for the CFA is concerned. Given the different operations of the different courts, I think the concept is the same. That is, when funds are paid into the court, you would require the order made by the court. You need to keep proper accounting records of the funds, and an audited account will need to be prepared every year for the Suitors Fund, and there will need to be a court order when payments are made out of the fund. So those are the same. So except for some minor differences given the differences in the operations of the courts. So it's not entirely standardized. It's basically the same. So I think it is already in the existing rules that securities may be paid into the Suitors Fund. Yes, for the High Court and the District Court, they accept securities as so with the amendment, then besides the CFA, for any courts with the need, then they can accept securities, including the land tribunals, the High Court, and the District Court. So we're moving an amendment to enable them to accept movable properties as securities. So depending on the operational needs of these courts, we have expanded the different forms of Suitor funds that may be deposited into the courts. Mr. Chen. Sorry, I've been a lawyer for so many years, but I'm still not very familiar with the operations of the Suitors Fund. Although very often we have made payments into and received payment out of the Suitors funds. So I'd like to know how these funds operate. Now, in future, does it mean that the right to make investment of such funds will remain the same if the funds are in the form of cash? And for people who are mentally incapacitated, if money is kept on their behalf, will the trustee have the right to make investment of such funds? And is there any, for example, a benchmark as to the amount of interest that should be accrued into the fund, similar to what one would get if one deposit money into a bank account? So So there should be a separate account. Is there a separate account for different parties, or do we have a single fund for everyone? And thirdly, there are trustees managing the Suitors Fund. Do you call them trustees? I don't know. I don't know whether you have judicial trustees or not. Do they charge a management fee? That is, how do they deal with the funds that have been paid into the court? Thank you for the question. Let me respond briefly, and then our accountant can elaborate further. In the present amendment, we have not changed the principles governing the investment of the funds. Internally, we adopt a very conservative approach in making such investments, normally in the form of fixed deposits. We've made reference of the investment guidelines of the government. Ms. Lee can certainly elaborate further on the guidelines. For every suitor, there would be a separate suitor's account. When we make investment of the funds, we'll make an overall investment. We would adopt a conservative approach, and the investment will be in the form of fixed deposits, ranging from 3 to 6 months. All the interest accrued will be distributed according to the principal sum that is in the account of each suitors. Now you accept securities as suitors' funds. So once you receive those securities, you won't do anything with them, right? They will be kept, and will be returned to the suitor later on. So there won't be any transactions or trading of such securities. Is that correct? So there's one more question that you have not answered, and that is whether or not a management fee will be charged. No, all the management will be done by, the cost of management will pay for out of general revenue. Regarding the securities, we will follow the court's order and deal with those securities accordingly. After we have received such securities, they will be, registered in the record. And once, when the court makes an order, we will conduct different transactions relating to these securities. We will dispose of the securities at specific dates, and the proceeds will be deposited into the accounts pending the final order of the court. So what happens if there are placements or rights issues? How would it deal with that scenario? Would you consult the party concerned or what? Basically, we will follow the court's orders. If the order has already been transferred to the account of the registrar, we'll deal with them accordingly. When there are rights issues, as in the case of the management of other stocks, we will follow the rules. So in other words, you are merely a passive custodian, rather than acting like a trustee. So you will not exercise any right to make investments. Any transactions that can only be made with the court's order. Now, within the profession, there have been suggestion or question as to whether or not you could play a more proactive role in making the investment. I think it is your answer that you will need direction from the court. If the amount involves a large amount of money, if a child has won the case, and then we may be talking about several tens of millions of dollars, and the minor may actually not be able to receive payment out of the fund until he reaches the age of 18. And a fixed deposit only pay a very small interest, and he may lose out. So the minor may need to appoint a guardian and propose an investment plan and seek approval by the court. So does it mean that the present amendment will not affect your future investment policy? That is, a suitors fund will only be placed in the form of a fixed deposit. Mr. Ho. I don't think your question is relevant to the rules that we are discussing today. We're not talking about, taking, managing the funds for a minor. Why don't we ask them to answer the question? Why don't you put your question in a different manner? Let's say if the lawsuit, lasts for a long time, let's say 3 years, and meanwhile the Suitors fund is placed in a fixed deposit, and then the party concerned may lose out if the money were kept in a fixed deposit account. Well, I think we need to have a secured and safe investment strategy. We do not want to increase the risk in the investment we make. So the return may not be the best, but we don't want the case to have to wait for so long. But the money that is paid in the court will not be placed with the court for a long time. I like to remind both the officials and the members to speak either English or Chinese and not cocktail language. Chairman, I don't think it's desirable that we speak in a cocktail language, but sometimes, we may, use technical terms. Chairman, if you have no further questions, I'd like to follow up on my earlier point. Well, to follow up on your question, Mr. Ho, I'd like to follow up further on that so that we are better enlightened. Normally, for the Suitors fund, what is the proportion at the moment? Are you talking about the aggregate sum? Let's say the party is involved in a lawsuit and he wants to claim. Let's say the employee wants to claim $1 million, against the employer. So it depends on the use, how the Suitors fund is used. The Suitors fund is part of the Suitors fund is security for costs. It is the intention is that if a party wins the case, there is a guarantee that the party which loses the case will have the means to pay for the costs. So that's security for costs. Another form the Suitors fund may take would be sanction payment. The sanction payment aims at ensuring or encouraging the parties to the case to resort to a settlement, so that there was no need to litigate.
If there is a plaintiff and a defendant and an amount is involved, if the defendant thinks that he has a weak case, then he can make use of a sanction payment, which is deposited at the court. The plaintiff would receive notice that there is a sanction payment, and the plaintiff can consider whether he accepts it. If he does, the case can be concluded, and no court time will be required for the parties to argue the case. Mr. Chan, we understand the process. I can understand that. When I was involved in business, there had been monetary disputes with overseas parties. But what about the percentage? I have received complaints from overseas companies saying they take a Hong Kong company to a court claiming $10 million, but then the Hong Kong judge may ask him to first deposit $5 million with the Hong Kong court. How do you calculate the proportion and the amount involved? If it is a security for costs, the court will consider the complexity of the case and the litigation costs involved. Say, for example, the plaintiff may be an overseas company. The defendant can go to the court and require the plaintiff to pay a security for costs. The normal criteria for security for costs is that the court would ask the defendant to produce evidence, and by that is meant how much costs would be involved in the eyes of the defendant if the case should go to court. The court would consider the information and then decide on an appropriate security of costs and require it of the plaintiff. Mr. Ho, is it that you have further questions? Yes. I was reading the amendments proposed. They are really very technical and very detailed. Do you want the law to be so detailed, say on what day the interest should be starting to accrue and what are the payment hours, etc.? These are so detailed. Why don't you just do it administratively, but choose to include it in the law? Thank you. I have the same observation, but I think it is about history. For the sake of procedural justice and due process, the judiciary would actually write what other departments do administratively into the law. I have the same observation since I have not been in the post for a long time, but we are proposing to change the payment out hours. And you can see that the amendment does not say from 10 to 12. We have taken a step back. We will say just to tally with the opening hours of the accounts office. Therefore, we are trying our best to simplify the law, but still I agree with your observation that it tends to be rather detailed. That is why, Chairman, I found this rather strange when I first read it, because you actually talk about the payment out hours. And also the registrar, that he has to issue receipts, etc. And there are other things that are rather strange. And also the day on which interest will start to be credited. Well, of course, you will not drag your feet in paying interest. And there is already an established practice. But if you consider to write the law like that, every time you want to make a change, you have to change the legislation. That is quite complicated. The government also receives deposits from the public in many ways. I think you can consider simplifying it. However, if the judiciary wants to be prudent, I will not argue with you. However, you now say that the interest begins to accrue from the third business day. But what is the practice now? According to the present law, especially for the High Court, in some circumstances, we only pay credit starting on the 14th day. If it is a security for costs, for example, the law is actually very old. We did not used to have computers, for example. Even if you have interest paid into the court, it might take a long time to apportion it to different suitors. But now we think with the advance in technology and for the sake of fairness, we can allocate the interest to different parties as soon as possible. And also, well, you can continue, Mr. Ho. We don't have a lot of members here. You will have all the time you need. I'd like to talk about movable property. Apart from securities, what are you talking about by way of movable properties? And would there be a problem of managing? Because some of the properties are bearer born. I don't know what it is in Chinese. In other words, as long as you are a bearer, you are regarded as the owner. So will there be a management problem? Thank you for the question. Under the High Court and District Court ordinances, we have defined what movable property is. I have asked judges how this is implemented. There will be a special reason for asking a movable property to be deposited. Say, for example, that may be the cause for litigation, and so it has to be deposited with the court first. And at the Labor Tribunal, they have talked about air tickets. You might have a domestic helper who should be given an air ticket to go back to her homeland, etc. And that might be the cause of the dispute. So in the High Court and District Court laws, movable property is already dealt with, and that remains unchanged. And the judge can say whatever is of value can become movable property. It can even be diamonds and gold. Therefore, they need a wider legal definition. So the judge or court can dictate that such be deposited with the court. Well, if you receive gold or diamond, which is of a high value, there is a dispute about these, and so the court will say, deposit that with us first. Who is responsible for keeping it safe? Who takes out insurance? And what about the insurance premium? Who will be paying for it? Thank you, Chairman. Ms. Lee. Valuable properties are kept in a safe deposit box. And in fact, it is of a different specification for different properties. At the High Court, the safe deposit box is of the highest specification. Have you experienced robberies or theft? No. I think that's almost it. I am here just to learn because I am not very familiar with the details. I think there is nothing technical. I have read through it. I think it's all right. I just wanted to go through it. But maybe we need to go through the rules clause by clause. I will ask our legal advisor for her advice. I have nothing in particular to say. Please switch on your microphone. I can't do it. I have to rely on technical help. Can you hear me now? Earlier on, the Legal Service Division wrote to the administration on the 6 sets of Suitors funds rules. We asked about the actual operation and also the definitions. The administration has already responded to those questions. And I have nothing to supplement here. I have read those letters, said Mr. Ho.
Okay, 咁睇下假如冇乜其他嘅問題。
If there are no other questions, we can go into clause by clause examination. We will ask the administration to take us through the rules. Assistant Judiciary Administrator, do we have the marked up copy? I haven't got the marked up copy. Can I be given a set or a marked up copy? Sorry, I haven't got it. The clerk can give you a copy. Maybe the legal advisor has something to say now.
唔該咪。
中文得啦。
唔係，大聲啲。佢哋要嗌佢開咪㗎。唔係。
Please switch on the microphone. Your microphone has not been switched on. Okay, now it is. Actually, LN 147 is a completely new LN. So it doesn't include a marked up copy. Members, please just refer to the paper for the meeting, or you have to go to the Gazette for the versions. And then with regard to 150, that is the Lands Tribunal Suitors Funds rules, there will not be a marked up copy because it is a completely new set. There is no old set of rules to amend. It is only when amendments are made that we would have a marked up copy, and that is for the information of members, please. Okay. Basically, we have 6 sets of rules to examine today. How should we proceed? Should we go for the High Court rules first? I think we can follow the LN, and first of all, we can go for the CFA rules. This set of rules is new. It is LN 147. or if you use our legislative brief, you can go to Annex A. I have all the numbers here with pagination. This is a so-called marked up copy. You mean you would use the legislative paper 33/11. Do you have that? Well, it's okay. As the legal advisor was explaining, the two new sets that refer to the High Court and the Lands Tribunal, there is no marked up copy for these. Well, it's all right. Let us go for this copy and start with the High Court rules.
好啊，我哋首先呢，就係先處理。
First, we'll deal with Gazette Notice 184. On page 001, interpretation. It is a technical amendment, and we are changing the words. We have inserted ledger account, for example.
如果冇其他嘅意見呢，我哋去0002。
If there are no views, we can go to another one. Sorry. Ledger account means any separate account that bears the title of a cause. What do you mean by the definition? Can I ask Mr. Chen to add? I don't understand the Chinese. Chairman, there is a name. It means that it bears the title of a cause. That's it.
議員 OK 嗬，如果可以嘅話呢，我哋去到0002版。
Okay, 0002. That's the page number.
第二頁嘅即係講
Clause 3. Lodgement of funds. That's Rule 3. We are making an amendment to improve that the receipt should be given, and there is a new form. I think members have discussed it at length just now, and we have even put in what should be included in the receipt. And then page 3, section 4, keeping of accounts and register. That is purely technical. Especially we need to define the word funds clearly.
該等儲存緊嘅任務。
I think there is also the investment. So this refers to the investments which are made pursuant to an order made by the court. Yeah, only when there is a court order will we make the investment, yes. So if there are no questions, we'll move on to page 4. There is an amended subsection 5. So we will, when making payment in the fund, we would differentiate different forms of documentary proof depending on whether or not the securities are listed. If the securities are listed, given we already have very tight monetary regulation, so there's no need to submit Form 3. It is only necessary for the registrar to we only won't require a certificate stating that the securities has been transferred as authorized. Ms. Lee, thank you. Yes, this is correct. What we are now talking about, I think in future, what will no longer be required to be put into Form 3 securities which have already been transferred in the name of the registrar. Madam Chair, I think the registrar also, are transferred from time to time. So it's in the name of the registrar, not in the name of the person who is the registrar. It is actually transferred to the to the registrar as the rank. I think the bank account is also opened in the name of. It's actually held by the registrar. I think the person may change. I find it rather odd that you would register the title of the account is the title rather than the name of the person. Right now, for example, the FS manages a lot of properties. You can use the name of the FS, but the FS may change from time to time. So in the long term, I think the registrar should be, a legal entity. But what happens if the person is transferred? So, I think we can, change it to registrar's corporation. The FS, has also, the registrar has a legal definition in the law, and so far we have not really encountered any difficulties with that. Thank you. Basically, the income is given to the government of Hong Kong. I think the title Registrar of the High Court, when payment is made into the Suitors funds, that would be the name of the account into which the funds are deposited. But in this account, actually our colleagues in the accounts department, well, I think it is stipulated in the law that two of our colleagues, so I think one of either of, we have two colleagues, either of which can sign on behalf of the account. All right, if there are no questions, we move on to page 5, which is the time of payment. We are proposing to align the payment out of the fund with those of the operating hours of the accounts office. Page 6. It's this is purely an amendment, a drafting amendment. Page 7. Again, this is a drafting amendment. Perhaps I should highlight the penultimate amendment, that is 3C. As watchman's fees, we've expanded this to include all expenses, that is money which have been received, but we will not be paying interest. All right, we can now move on to page 8. I'd like to draw members' attention to 3 capital AB, where you find a triangle. 3 capital AB is a transitional provision. That is, after with the amendment of the interest, the 14 days will now be changed to 3 days. And with the commencement of the rule, money which has been paid in the court, we want to ensure that they will benefit from the new arrangement as well. Yes. We now move on to page 9. I think these are, I'd like to highlight particularly the one with the square, 3 capital C. 3 capital C involves, Order 62A, we have to actually wait until after 14 days before we start to accrue the interest. Under the High Court rule, there is under Order 22, again, we have to wait for the 28 days to lapse before interest start to accrue. The rest are just technical amendments. Page 10. Rule 21. Again, this is a drafting amendment. I don't understand what 21(1) is about. I'm looking at page 10, 21(1). That is the different types of suitors funds. If necessary, Ms. Lee can supplement. If anyone would like to find out how much is money he has with the court, he can apply for a certificate to find out how much money is left in his, in the funds that he has with the court, and how much has been paid into and how much has been paid out, by the court out of this account. We do, put in all the details into the law. So does it have to be the suitor himself, or if someone is mentally incapacitated, it would have to be his guardian? Well, it could be interested parties, so other people can sign on behalf of the suitor. Well, we don't have anything to add here, but if we are required to provide a detailed list of what is in the account, we can accept application, and if upon application, we can provide a list of the account to the person who makes such an application, or the guardian of that person. So I think you've added terms like the registrar here to improve on the drafting. Next, we come to page 11 again. These are, drafting amendments. Page 12, the form. Members may not be interested in these minor amendments to the to the forms. For example, amending the year from page 12 onwards, all the way through to page 16 are just amendments to the forms, and they're rather minor amendments. Nothing that is really, of importance. So we may now move on to the District Court Suitors Fund rules, and this is LN 149. I think the amendments here are almost identical to the proposed amendments to the High Court rules. Do members want us to walk through this again as well? No, I don't think it's necessary, Madam Chair. I've checked that myself already. Thank you. Well, in that case, we can now jump to the Labour Tribunal, LN 150. First of all, Section 2, we've expanded the definition of funds. We accept movable property, and we've made reference to movable properties and explain what it is. I've already said that the Labour Tribunal may need to deal with plane tickets in cases which involve labour disputes. So we've expanded the definition. Section 3, again, simply drafting amendments. Page 2. I think we touched on this earlier as well. That is, we clearly, spell out what it should be, in the receipt. And it's the same as in the case of the High Court. Page 3. So what does pay out of and payment means? Previously, the Labour Tribunal, for the suitor funds paid into the Labour Tribunal, the only cash would be paid into the fund. So but now we've expanded the definition of funds to include movable property. Normally, we do not say pay a movable property. That's why we use the term pay lodged. So page 3. Now that we accept movable property, as in the case of the High Court, we have to require for a registrar to record all the movable properties which have been received. So this is simply to align this with the practice of the High Court and the District Court. And at the very bottom, where you find a square, this is this is actually the time for the payment out time. Page 4, again, these are drafting amendments involving the sums or the amounts. Page 5, pages 5, 6, and 7 are just amendments to the forms, and there's nothing that should warrant members' concern. We may now move on to LN 152, Small Claims Tribunal Rules. Page 1, it's about the receipt. Page 2, payment out of the fund, the time for the payment out of the funds. I think I've already explained this to members earlier. Page 3. We've amended Registrar of the High Court to Registrar of the District Court. Because for the Small Claim Tribunal, this is done by the Registrar of the District Court. So I think for the sake of consistency, we should also leave it with to the Registrar of the District Court. Normally, there is only one registrar in each court. Well, there may only be one such post, but actually we have about 10 registrar. We have a registrar, we have an assistant registrar, and senior registrar. So all these are provided for under law. There are four levels. For a small court like this, one single registrar would suffice.
If there are no questions, pages 4 and 5 have to do amendment to forms. I don't think we should take up more of your time on these. Simply put, we have already done clause by clause to the existing 4 sets of suitors funds rules, and we have 2 new sets of rules. Do we want to go into those? Yes, I think so. Let's carry on. If that's the case, I would propose that we proceed with the CFA rules first. We can use the gazetted version as the basis. That one is actually more detailed. We have in fact taken the High Court rules as example. The first one, commencement. After we have gone through all the 6 sets of rules, since we need to update the computers and we have to do a lot of work internally, we will find a date that will be appointed for the coming into operation of all the 6 sets of rules. The second one, interpretation. This is the same as what we have already seen. And then I like to mention that here funds would only mean money. It would not include securities or movable property. Clause 3, payment into court. How funds should be paid into court. We would set up a new account particularly for the CFA, and even the name of the account is given. Clause 4, receipt. We have already gone through that. Clause 5, keeping of accounts. Again, we follow the approach of the High Court. How funds would be subject to a very prudent system of management. And Clause 6, annual statement of accounts. This is also a very prudent approach. Chairman, when you talk about annual statement of accounts, is it to be submitted to the court? It is for the registrar to review it. Is that right? Sorry, speaker not coming through. Please switch on the microphone. The accounts would be submitted to the Director of Audit. We would issue an audited account. But it will not be as detailed as bearing the names and the amounts. You have the accounts, but then in this statement, it will not be so detailed as to carry all the names and the amounts. No, not in the accounts, but in our system, all the accounts are there, and in May every year, the Director of Audit would send auditors to look at the accounts. Can we go to Clause 7, payment out of funds in court? When a check would be issued or when money will be issued, and as Ms. Lee said, 2 persons will have to sign it. If there are no questions, Clause 8, payment, sorry, Chairman. Why do you stipulate that if it is cash and if it is over $250, it must be done by check? Why such a low amount? Sometimes at the High Court, I think we have received cash over $1,000. This is historical legacy. In fact, we want to minimize cash flow. It would be easier to do audit trail if we use checks. Next, Clause 8, payment out to be ascertained by certificate of registrar. Okay. Clause 9, payment of costs. Again, it has to be accompanied by a certificate of the registrar. And also what kind of information should be included in the certificate is very detailed. Clause 10, order directing payment out of funds to describe persons entitled to payment, etc. This would include the name of the person or the business name. Again, we have copied this from the High Court rules. Clause 11, also copying it from High Court rules, order directing investment of funds paid into court, and we stipulate the process to be followed here. Now we can go to Clause 12. Order directing other dealings with funds paid into court. And that is, if it is dealt with otherwise, then by payment, withdrawal, or investment, we would follow what the High Court rules state. Clause 13, the same as High Court, carrying over of funds to separate account. Clause 14, again, very similar to the High Court, power of registrar to invest funds. And how interest will be recorded. Please look at bracket 4. You can see that interest will be credited beginning on the 3rd business day, which has been shortened, of course, from the 14th day. Chairman, you said the registrar would not actively invest funds. How is it that in 14.1a you seem to say that funds can be invested in such manner as the registrar thinks fit, and the preamble in 1 says unless an order directs otherwise? It seems, as stated, you can have the discretion to actively invest the funds. The law provides a broad context, but as members have heard us, we have a very conservative investment strategy, and we have a standing way to do it, and that is just to deposit it in a fixed deposit account. But it seems to say we have discretion, but actually not so practically. If that's the case, you can always change the policy. That was what I was asking. You can change the policy and say, according to the trustees' ordinance, you can have authorized investments as those authorized by law, like buying blue chip stocks. And you can do that without changing the law. Is that right? Thank you for the remark. I think this does not only involve the law, but as the judiciary, we have to be mindful about investment risks. That is a more fundamental issue. It is not just what the law permits. If necessary, we have to do a very detailed review because, in fact, that would involve a lot of financial rules. I think Mr. Ho has just made a comment. Well, yes, it writes it in a very broad way, but I find it strange that they actually do not do it this way. It happens with a lot of court rules and laws about the courts. There will be room provided, but very often we don't exactly do all the law allows us to do. Clause 15, surplus income. If there is surplus income in the account, it should be transferred to general revenue. 16, same as High Court, cost of administering Hong Kong Court of Final Appeal Suitors Funds account. This is done by our own staff, but there is still cost. This is about staff cost, and it will be paid out of general revenue. Clause 17, certificate of amount and description of funds. And that is, if the registrar should receive a request from any person claiming to be interested in any funds, the registrar must issue a certificate of the amount and description of the funds. Clause 18, transcript of account in registrar's books. That is, on a request signed by a person claiming to be interested in the funds, the registrar must provide a transcript of the account. This is similar to what the High Court does. Clause 19, again, same as High Court, transfer of unclaimed money in court. The Chief Justice, on application by the registrar, may order the sum to be transferred to general revenue. The last one, Clause 20, is a transitional clause. Right now, the management of funds of the CFA is done administratively, but later it will be a statutory arrangement. To avoid legal disputes, we have included this clause to say that such a change will not affect any funds that has been deposited into the CFA. And then we have forms. Sorry, Chairman. Yes. Can I go back to 15.1? I still don't understand why there will be surplus. Can you comment on that? 15.1. You have separate accounts. The interest would be assigned to the different accounts as well. How come you have surplus? Thank you for the question. As I said, when money comes in, if it is a sanctioned payment, we will immediately deposit it into a fixed deposit account. Before it is mature, the interest will not be assigned to the appellant, and the interest can accrue over time, and this will be known as surplus, but we will return it to the account holder. But sometimes the money can be unclaimed for many years, and for how long will you keep the money? That happens with banks as well, only up to 5 years. And one rule will say it will be referred to general revenue. Which one? Where does it say 5 years? It's in 19.1. If any sum of money remains unclaimed in the court for 5 years, the CJ will order the sum to be transferred to general revenue. But 5 years may be too short. When do you count the period during which the money is unclaimed? Do you count from the day you notify the people to come and claim the amount? 5 years is too short. Is this the present practice? Our accounts colleagues tell us that if the fund has no activity for 5 years, we will continue to give notification for people to claim the fund because there is a court order. But if there is no reaction for 5 years, then we will transfer it to general revenue. In other words, the person is entitled, but he does not claim it. No, my question is, even if it goes to general revenue, and then for some reason the person suddenly appears to say he has been imprisoned elsewhere and he was physically unable to claim the amount, then can he still get it? Would you hold it as a trust, right? But the money still belongs to that person. Ms. Lee? Thank you, Chairman. Until now, there has not been any application for unclaimed funds. But if there is one, there is a mechanism for us to ask the Treasury to allow us to recover the funds. Is that right, legal advisor? The rights of the owner of the fund will not be lost. Is that right? Well, I can just say that in this clause, it doesn't say how it will be handled. But Ms. Lee is telling us that there are administrative guidelines that this can be done. But perhaps you can ask the administration to supply additional information if there is a need. If I just read the rule as it is drafted, I cannot answer members as to what can be done and not under this rule. Chairman, I think the JA and the Treasury accountant have said something right. I can accept what they said. This is a management arrangement. The money will be there, but no one claims it, so they refer it to the general revenue.
That doesn't mean that the original owner's right will be deprived of. So my understanding is that if in future the person comes forward after 6 years, then they will make the arrangement for the owner to claim his the money. Yes, I think he may need to apply for an order by the court. With the court's order, they can go to the Treasury and apply for the recovery of the funds. Yeah, so this provision will not result in the original owner to lose his right. Yes. Yes. Okay. Well, in that case, I propose that we move on to the last set of rules, which is the Land Tribunal, and this is LN 150, and this is brand new. The Land Tribunal rules are very similar to the Suitors Fund rule for the District Court. The first one is the commencement, and number 2, interpretation. And under this rule, there is a very broad definition for funds, including cash, securities, and movable properties. Next, lodgement of funds. And clause 4, the requirement to issue receipts. Clause 5, keeping of accounts and register. Clause 7, annual statement of accounts. I think it's very similar to what we have just looked at earlier. Next, clauses 7 and 8 refer to securities. In the CFA, securities are not accepted, but here securities appear for the first time. Clause 7 stipulates that all kinds of securities may be lodged in the tribunal, and provisions are given as how they are handled. And clause 8, the principal money and dividend in respect of or on securities are to be placed in the registrar's books. In clause 7, you provided for a definition of securities. We've made reference of Cap 571. Our legal advisor just told me that you have already provided for a definition under 571, Cap 571. We can try to, make it up. Normally, they would refer to securities. Securities and bonds. We will provide that information to the legal advisor later on. Clause 8. All these dividends and money would need to be, placed in the registrar's books. Clause 9 is about payment out of money lodged in the tribunal. We've looked at that already earlier. Clause 10, payment out to be ascertained by certificate of registrar. 11, payment of costs. Again, you require a certificate of registrar. Clause 12, we didn't discuss this in detail, but this is provided for in the High Court rules, and this is about payment out, transfer of funds to personal representatives of persons entitled to payment. Madam Chair, you refer to records of the funds. Does that include estates? Is it and for the registrar to make the application for would that be included? Well, I said that the High Court provide for different types of money in the Suitors Fund, and they include, for example, alimony and so on. Anyway, so long as money has to be placed in the court for some time and paid out after some time. So the registrar may have the right to apply for the inheritance of the estate. If he is successful in doing that, will the money received be put into the fund? I understand that there is another ordinance to deal with estates. But if someone now, what we're saying here is that if A is entitled to receive a payment, but if unfortunately A passes away, what's going to happen to the money? It would have to be for someone who is entitled to receive the payment. Clause 13. Order directing payment out, transfer of funds. And then you have to settle the name of the person receiving the payment and so on. Clause 14, investment direction. I think we've touched on this already. We also already touched on 15 as well. Order directing other dealings. And clause 16, carrying over funds to separate accounts. 17 is about power of the registrar to make investments and also interest. I think this is there are more details here compared with the CFA because it's the same as the rule which apply to the district court. Okay. Please go on. Clause 18, I think we've also mentioned this before. The surplus will need to be, transferred to general revenue. Clause 19, cost of administrating the funds will be paid for by the government. 20 and 21 involve enforcement. We didn't touch on this earlier. That is, if money will need to be paid to some person, and we need evidence to prove that the person is still, living, and you need an affidavit to prove that. To prove evidence of by affidavit of the life or the fulfillment of condition. 22, if someone asks the registrar about the amount in the fund, anyone with an interest in the fund will give him a certificate. 23, anyone who want to acquire details about the account can be given a copy. 24, transfer of unclaimed money to general revenue. 25, for the sake of certainty, we want to ensure that the funds to the tribunal immediately before the commencement of the rules will not be affected. Any questions? Mr. Alberto, do you have any other questions? We don't have the rule for the competition tribunal yet. Right. Would there be a separate rule for the competition tribunal? Well, the competition tribunal is about to be set up soon. So for that set of rules, we had already submitted those rules, that set of rules to LegCo earlier on this year, together with the other 4 sets of rules. They have already been approved by LegCo through negative vetting in July. We have already, proposed a commencement notice that is on the 14th of December. Together with the commencement of the competition ordinance, they will come into effect at the same time. And they are more or less the same as the rule pertaining to the High Court and the Lands Tribunal. All right, if there are no further questions, I believe the Bills Committee has concluded its scrutiny of these rules. Madam Chair, I think I'd just like to add that we've just looked at the Chinese version of the rules. I hope the legal advisor will also take a look at the English version as well. Legal advisor? I will certainly take a careful look at the English version. If I have any points to raise, I can, inform members. Both members and the administration had an exchange regarding the definition of securities. I understand that in Rule 150, there is no separate definition for securities. However, under Cap 571, Schedule 1, there is a definition for securities stipulating different objects which are considered to be securities. And if I go to Clause 7 of 150, I think you have made reference to Schedule 1, Part 1 of Cap 571. So basically, are we talking about the same thing here? Yes. We're worried that we just want to be safe and promise to come back to members with the information required. We don't want to make up a definition ourselves. Right. If there are no further questions, then I think we have concluded our scrutiny of the Suitors Fund rules. I will report to the House Committee on the 6th of November, and we will be the expiry of the scrutiny period is 18. So if members wish to move any amendment to these 6 rules, please do so before the 11th of November. So we've been most efficient. There's no need to convene another meeting. And the committee is now disbanded. Thank you very much.